The president and many others in his team welcomed the verdict, welcomed the final decision of the court, said they would abide by it, and very quickly then went into the process of trying to come up with a new amendment to the law. And then suddenly things turned around. What's happening here?
One could sum it up as a post-2010 executive irritation with the state of the law in this country, because it's actually the Constitution of Kenya 2010 that complicates things, and I use complicate in advisedly, because that is the Constitution that actually allows people to have a conversation about how they can be ruled. It's no longer open fiat where you can do what you want. And clearly, the executive has displayed irritation by that somebody can go to court. And by the way, somebody used to have a name. It used to be Okiya Omtata at some point. But these days, you can see that the president has taken to saying 2 or 3 people. They have not been mentioned. But look, the Constitution actually allows 2 or 3 people, and including even just one person, a very regular mwananchi, to go and be heard by the court, and by the court of or law that will then interpret to that person whether their rights are violated or they are being respected in as far as how that law has been made. So, summary of it, this is executive irritation. It never used to work like this. And I think what we are seeing is it's very difficult for the government to just do what it wishes, because there are a lot of checks and balances in place. Now, the Constitution actually also expected that the legislature will be also playing a role in checking the other arms of government. So I think if everything works as the Constitution of Kenya 2010 envisages, then governance can be a very irritating space. You see, in a place where you have an independent judiciary, an independent legislature, and an executive, you will find that even Parliament would be the ones that actually be holding the executive to account on the passage of laws. In the US, which is what we basically borrowed in terms of the structure of our 3 arms of government, the president has to really negotiate with the majority leader, right, in the House of Representatives. You have to negotiate with Congress. You have to have this back and forth. You always see the stories about government shutdown, where a budget is not passed because sometimes it's even the leader. Actually, all the time, it's the leadership of Parliament that makes that decision. So I think this is just one step. It's the judiciary and the petitioners that are going to the judiciary that are irritating the executive. Let's remember that the principle in Kenya is such that the judiciary and the court is basically blind. It has to be notified. And this is one thing that really needs to be appreciated, because the judiciary never comes out here and says, oh, that law is bad. It has to be approached. It has to be informed. And the next thing they tell you is, what is your argument? Set your grounds. And then you say, yes, in accordance with the Constitution, this is not right, or this is not the way it is supposed to go. So I think we're still one step away from total irritation in terms of how governance used to work and how it's supposed to work right now. You're actually supposed to have a more irritating legislature than we have an irritating judiciary.
But what is irritating the executive, Sam?
Well,
I mean, I thought they had a fairly good day in court when it comes to the Finance Act of 2023. Right. You know, they had some pretty good wins, you know, apart from, say, 1 or 2. Why would the executive be irritated by decisions by the judiciary?
Well, first of all, that particular case on the Finance Bill 2023, later to become an act, of course, it's in operation now. Every Kenyan has felt the impact of it. It was first a lot of wins, like you say, especially when it came to the question of taxation. The only question, or the major question, was on the housing levy, and the judges themselves say that this is unconstitutional, null and void. They gave the reasons, but then again, they gave a stay order for 45 days. It was supposed to expire on the 10th of January, but of course, that was extended by the Court of Appeal because the proper appeal has already been filed. So you look at the current administration and you see, of course, they have many plans that they want to achieve based on promises, but also the ambitions of the administration in transforming the country in a way that them can at the moment. But then again, it goes against that spirit, because that very afternoon, the president said that we are going to comply, and those gaps that the court has pointed out, will fix them. Of course, after that, it's open to interpretation, and that's why today you have an affordable housing bill of 2023 that is in Parliament. The other irritation has been that someone went to court and said we want this public participation blocked, enumerating the reasons. Of course, the orders were given, but obviously you've seen Parliament coming in and saying, or giving a different analysis of the exact thing that the court did. I think it was sitting in Nakuru, and them saying that they cannot be stopped by another arm of government to do what is primary to the House of Legislation. But then again, alongside all that irritation, there was the second set of the health laws, the 4 of them that were passed, including what Aaron Cheriot is describing, that there's an amount of money that is supposed to be set aside by the government to be in a position to take care of chronic illnesses. So those health laws are supposed to be implemented. Remember that the operation of that law, I think it was on the 22nd of November. It means that within the next 1 year, we're now we're almost completing the first 2 months of that time. We should be expecting that NHIF should cease to exist. That should be by November of this year. So time is running. The government has just about 10 months to make sure that the Social Health Insurance Authority is in operation. So the president and the administration are frustrated because you cannot go back to the previous law that made sure that NHIF existed. You have plans that you want to achieve. You have the Digital Health Act that is supposed to be enabling the government and institutions come up with a database that keeps your records and everyone's records. So that frustration that we want to do this, it is not possible because someone went to court. That is the irritation. But then again, the president has said that kuna wezi, kuna watapeli umeenda mahakamani. Unfortunately, the constitution talks about any person. And I bet, including a thief. I'm not saying that those that have gone to court are thieves.
But everyone has their day in court.
But
has a right
person,
to,
as long as they are a person, they can go to court.
Indeed, and that's that irritation, I think, that came out. Let's listen to the president, followed by Senator Aaron Cheriot, on exactly that irritation.
We are going to deal firmly with those who want to go and hide behind the independence of the judiciary, so that they can sabotage the development of Kenya, so that they can continue to benefit from NHIF where they are siphoning money.
Katika hiyo sheria, Rais ameweka hata program ambayo inaitwa Chronic Diseases and Emergency Fund ya wale wananchi ambao wanaugua ugonjwa wa saratani, diabetes na hele magonjwa ambayo inalemea wananchi. Rais ametenga kando pesa ya serikali kulipia nyinyi bill hizo. Lakini kwa sababu kuna watu wanaendesha mahospitali bandia huku mitaani, wanashikana, wanaenda kwa mahakama, judge mmoja tu hivi anaambia rais na nyinyi wote ati tunyamaze na tuzidi kuteseka.
Well, I guess the idea of the executive being irritated by decisions that are made in the judiciary is something that we have seen historically in this country. When the courts ruled against the 2017 election and nullified it in 2017, remember there was a chorus of the revisit by, the president then and his deputy, who is the president today. At the time when the courts again ruled against the BBI, What did we see thereafter? The very judges who were a part of that process were then never appointed by the former President Uhuru Kenyatta. When the court has ruled now against Deputy President when he was Madeira Member of Parliament in the case of corruption, and then we started to see that he was, taking a petition to the JSC. And now the courts have ruled against the housing levy, declaring it, again, unconstitutional, null and void. Now we hear talks of corruption. And so, some of these things, there's a whole pattern and rhythm, and you can see it. When the judges rule against, or the courts rule against the government, then there is a problem. Then we have to revisit. Then we have to take a look at the courts. Then we have issues with the courts. However, when the courts do rule in favor of members of the executive or the executive as a whole, then the courts are hailed as speaking to the will of the people and upholding the same. In fact, President William Ruto now did hail the ruling of, the BBI when that was thrown out due to procedural reasons, and we all know what the court said then. He hailed that verdict and that ruling, and the will of the people has been adopted, and that the courts have stood firm and stood with the people. And we all know which side of that debate, he was on at the time, as well as, several other moments. So there's clearly a pattern here. When they rule in your favor, they're good. When they don't, they are corrupt. Another similar pattern I find is, now again, there's claims and very blanket, sort of vague claims about corruption. And that's not to say that corruption does not exist in the judiciary. Corruption exists everywhere. But then again, just like with former President Uhuru Kenyatta, when he refused to appoint the 6 out of the 41, for months, in fact, how long did they remain not appointed? Close to a year. He never gave specific evidence. And everybody said, you are the president. You sit in a position where you get, intelligence. Why not take whatever issues you have, whatever allegations you have to the JSC and have those done? He never did. Until the moment he left office, he was never specific about Judge X. These are the issues. Judge Y, these are the issues. And now again, we see exactly the same thing happening. The judiciary is corrupt. Judges are corrupt. They're receiving bribes. They're being influenced in the decisions they make. Once again, if you've got the evidence, why not present that to the JSC? And one of the interesting things I find about, even when you look at the membership of the Judicial Service Commission, the president has no less than 2 representatives, 1 man, 1 woman, to represent the public. These are not lawyers. They're appointed by the president, of course, with approval of the National Assembly. And so he has, or rather, the institution of the presidency has representation at the JSC. This can all be very easy when you just say it is so-and-so, these are the issues, and then we go into a tribunal. We've seen the JSC with some of their tribunals. Judges have been let go just recently. We've seen that. But yet here we are. There's a pattern here, Linus.
And it is a permanent pattern. You shouldn't expect this to end. This is the nature of how politics basically works. And I'm going to draw examples, not just from here, because first of all, what we are seeing is exactly a continuation of what former President Uhuru Kenyatta used to do. This was the attitude towards the judiciary. Remember, after the 2017 ruling against his election win, he promised to revisit. And by the way, it started looking like a purge, another different kind of purge, where now judges were supposed to be replaced and appointed in certain ways. And remember the fight to, first of all, control the Judicial Service Commission, which is the body that is in charge of the judiciary. But if you look further abroad, the Supreme Court in Israel irritated Prime Minister Netanyahu to the core, because he didn't want the Supreme Court there to make decisions against government decisions. It was a very interesting kind of thing, where Parliament passed a law that now tries to say that government decisions cannot be challenged in the Supreme Court. And the Supreme Court said, no, we will have the jurisdiction to do that as per the Constitution. Not as per the judges, but as per the Constitution. Now, US, you see all these arguments about election win and loss, but also the battle to control which party nominates a judge to the 9-bench Supreme Court. It's a big battle because you always want to make sure you get judges that will try to twist the law to fit your political agenda. And the principle of the doctrine of separation of powers tries to cure that by first of all giving judges independence to decide, to make those decisions. And I just want us to listen to the Chief Justice, Martha Koome, talking about the decisions of a judge, because every time you have Kenyans reacting, either commending, congratulating judges, actually, judges expect nothing out of that. They don't expect jeers or cheers from those rulings that they make, because they have the mandate and power to decide. Let's just listen to the decision on independence of judges.
Of a judge or a judicial officer made in the course of the discharge of judicial function cannot be questioned except through review or through an appeal. And a judge is not liable in an action or suit in respect of anything done or maintained to be done in good faith in the lawful performance of a judicial function.
Now, this was in direct response to what the Deputy President, Rigathi Gachagua, had a few days earlier argued when he said that he is going to move a petition against Justice Esther Maina. Remember that in number 8 they said that that his money was declared as proceeds of corruption. Let's listen to Deputy President Rigathi Gachagua talking about his hard-earned wealth that was declared by a judge as proceeds of corruption.
Huyo judge, through corruption, declared my hard-earned wealth proceeds of crime without giving me an opportunity to be heard. Against the rules of evidence, where he who alleges must prove. We made an application to cross-examine the investigator, akakataa, kwa sababu anajua there is no case. Na evidence tuko nayo vile ilifanyika.
Now, this is what the Chief Justice is saying, that you cannot say this judge ruled against me and this decision amounts to corruption, because the Constitution also sets the grounds for the removal of judge, and you have to really prove there is actually gross misconduct as well as part of grounds for removal. And when you look at these politicians questioning the decisions of the court, you don't go to court and then expect a particular outcome, require you to make a particular outcome. And if it's not that outcome, then that amounts to corruption and the many things that they are saying right now.
Indeed. In fact, he then went on to say he was going to do something about it. Let's listen again to the Deputy President, where he actually said what he was going to do about Justice Esther Maina.
Amechallenge sisi tutoe ushahidi. I will lead by example. On Thursday, this coming week, at 2:15, I'll personally present a petition before Lady Chief Justice Martha Koome against Justice Esther Maina for her removal from the judiciary for misconduct and corruption.
Of course, Thursday, 2:15, that was a couple of hours ago, came and went. And now we understand what he has decided to do is give dialogue a chance. So here we are again talking. But this is why he's giving dialogue a chance, because interestingly, the idea of dialogue and talking was in fact raised by the Chief Justice herself, Mr. Sen?
He might have received reports because we have the various machineries and agencies that are charged with the responsibility of correcting information. And we would like to engage him so that he can give us that information. Because we all have a responsibility of solving our problems in this country. We all recognize corruption is endemic, it is a problem, it is unacceptable, it is condemned, it is actually a criminal offense.
Okay, so we're talking again, Sam.
Right. I have a few things to say. First, I find it interesting. I find it interesting that I don't know that she's trying to play safe or what, that the president might have received certain information from different agencies. I find that concerning because, yes, the president may have machinery, may have the National Intelligence Service, may have different armed security forces in the country that may have information. But the Chief Justice also has a system that should actually tell her what's going on within the institution that she's leading. She has a line of how complaints are given. There's the National Council on Administrative Justice that incorporates different agencies in the justice sector that come together to seek reforms that would assist in the furtherance of justice in the country. So could it be that there's certain information the executive is accessing about the judiciary that the judiciary does not know of its own staff? Maybe there is, but I find that admittance quite disturbing, that actually now the source of information about the conduct of the judiciary will be coming from the executive. Yet, like she said, if anyone has a complaint against any judicial officer, file the petition with the Judicial Service Commission and it will be processed based on the procedures that exist. So how many petitions has the president presented to the Judicial Service Commission? Because I would expect otherwise, that the president is appearing before the the Judicial Service Commission, either by him, as himself or through a representative, presenting that petition. You see, the deputy president promised, and the promise has passed, and of course the communication this morning was that notes the current national discourse on judicial transparency and application of Article 10 of the Constitution of Kenya on the conduct of judges and other judicial officers. So first of all, his own complaint is personal, and it's about a decision that was taken by a judge on a matter that was presented by ARA. That would want to repossess certain property that is suspected to be have been acquired through proceeds of crime. And so, yes, he may have complaints about how he was treated, but the last time I checked, that man was actually released. That complaint has to have the grounds as to why a judge is being accused of corruption. So when he yields to talks, what happens to the truth that he owes Kenyans in as far as this judge that may have been involved in certain actions of corruption? So I don't know where we go from here, because truly speaking, when you look at all this communication that is coming from the judiciary, from the executive, but going to end up at talks, and look what has been happening in the country. The president wants to pass something in parliament. He calls for talks. With who? Members of parliament, be it in parliamentary group meeting, be it reaching out to members of the minority party that are not agreeing with the positions of the minority parties. So they are called to State House, they have a conversation, and that whatever he wants to pursue in parliament passes. There's a problem of cost of living. There's a problem of demonstrations in the country. The president calls for talks, of course, gently with the members of the opposition. So conversations happen. There's the National Dialogue Committee that comes up with a report. There is also divisive, in as much as it is also uniting some of the perspectives from the different political sides. So now we are going to the next level of dialogue. So what shall we call this? So there was National Dialogue Committee talking about cost of living. So what's next? Is it national? Is it arms of government dialogue committee, or what's going to happen there when the talks begin?
Well, if it's one thing we can find, it's a name for it. We had NADCO eventually, the National Dialogue Committee.
Yes.
Yeah.